attorney is joining us remotely. Mr. Collins, Chief Deputy from the County Attorney's Office, is here in the courtroom. We're set for jury trial in this matter on May 13th, and I'll let counsel know that this is the priority case for me on that day. Mr. Ramos, I think you had filed a notice that the defense was ready. Is that still true?
That's correct, Judge. There's I guess, a slight scheduling issue I wanted to address, but yes, Judge.
Okay. And Mr. Collins, I believe Ms. Ortman, or no, Mr. Alcorn had filed a notice that he was ready. He's still ready to go?
That's what the file indicates, Your Honor.
Okay. Mr. Ramos, what was the small scheduling issue potentially?
Well, Judge, this is a 3-day trial. Let me pull, I got to pull it back up. I'm sorry. Let's see. I had previously reset, my staff had reset, not a felony, it's a bench trial in Parker on May 15, and we had reset that from a previous date, and this client was extremely anxious and didn't want to reset the first time, but we did. And he's extremely anxious to get this done on that day, and so that's obviously our third day of trial on this. I don't know if it'd be too much of a problem to carry the third day to the following Tuesday if the court's open, or if we could just bump this a week or something. I don't want it to go out any further, but I'd like to get that Parker matter done. He has two cases that we're doing back-to-back trials, and I'm being Parker all day. I'm supposed to be in Parker all day that day.
We could potentially try to do a Tuesday selection. If we could pick on the 12th and then go the 12th, 13th, and 14th, Mr. Ramos, would that work for you?
Yes.
Mr. Collins, do you know if that would work for Mr. Alcorn? Yeah, and can you click on your microphone? It's off. Thanks. Yeah, so start on the 12th, yes.
Usually we clear trial days, so I don't have that on the cover sheet. If you give me a moment, I can try to look at his calendar to see if there's something on it.
You could do that.
May 12th, why does he have a Zoom meeting on there? I don't see anything scheduled other than a Zoom meeting, but it doesn't say what for. It's a Division I. I suppose he can file a notice of conflict or something,
Okay.
just because I'm not seeing anything on his calendar.
Okay, so Madam Clerk, I'm going to affirm our jury trial with a slight modification, that the trial will go from the 12th through the 14th. I'm going to need to make sure, I'm pretty sure we can have the room on the 12th, but we'll need to verify that because we don't normally have priority on the 12th, but I will work on that.
So is it 12, 14, 15, or is it 12, 13, 14, 15?
12, 13, 14, because Mr. Ramos, you're in Parker on the 15th, right?
That's correct, Judge.
Yeah, so it'll be 12, 13, 14, so Tuesday, Wednesday, Thursday. So, Madam Clerk, I'm going to affirm the trial, but with the modification that it's May 12th through the 15th. I'll ask that counsel submit a proposed statement statement for the questionnaires by end of week. I'm going to order that summonses be issued for this matter. Mr. Ramos, you'll file a motion to transport?
Yes, Judge.
Okay. Okay, and then Mr. Ramos, the state had filed a motion under 404B. Have you seen that motion?
Was that a notice, Judge?
Yeah, it may have been framed in the nature of a notice. Let's see here. It was from May 10th.
Okay.
Yes. And
Yes, and so what I planned on doing with, if that's what you're referring to, was filing a motion in limine
okay.
concerning that.
And then probably what I will do is, once I get that, if I need to, I'll set a hearing on that. Madam Clerk, I am going to set a hearing on May, just a second, let me get my thing here. On May 11th on my Globe calendar at 4 o'clock to review jury questionnaires. All parties in council may appear remotely for that. Mr. Ramos, can you still hear us?
Yes, Judge.
Okay,
Can you
we
hear
just
me?
lost our we lost our TVs, so we can't see you, but I can still hear you. Okay, and then
Yes, I can hear.
Mr. Ramos, how soon will you have your motion filed on the 404B issue?
It's pretty much formatted, Judge, probably this week.
Okay, good. As soon as you get that done, that'll be great. I'll take a look at it. Will you make sure you send a copy of that to Veronica, so I'll make sure I have it in my inbox?
Yes.
Okay. Okay, Mr. Collins, anything else then on Mr. Hutton?
No, Your Honor.
Mr. Ramos, anything else on Hutton? Not for the court, Judge, but if Mr. Hutton can hear me, Glenn, we are, my staff is coordinating through CO3 or attempting to a meeting this week. Okay, can you hear me?
Yeah, I can hear you.
Okay, fine. We'll be talking to you this week.
I was wondering if anyone's heard from Adam Susser.
TCM.
I have not.
No one?
No.
Okay.
Okay, that'll be all done on Mr. Hutton. Mr. Hutton, I'll see you in Payson, May 12th. Thank you.
Yes, sir.
Okay, can you reach out to Michelle and see if she knows why we lost, if there's anything we can do to fix that, or else we'll need to get IT. Okay, Mr. McCarty, who do you have with us? Okay, if you and Mr. Lindell want to make your way up front.
That's it, huh?
Okay, and Mr. Hutton, you're done. Thank you. Thank you, DOC staff, for making him available.
Perfect. You're welcome. All right.
Okay, you ready to go to the next one? Okay, next matter is State versus Lindell, CR 2025-50. I'll note that Mr. Lindell is present out of custody, represented by Mr. McCarty. Mr. Collins, Chief Deputy from the County Attorney's Office, is here. We're here for a trial setting, possible change of plea. Mr. McCarty, can you give me an update from the defense perspective?
I can, Judge. We received an offer from the state on Thursday. It's been provided to Mr. Lindell. It's got an expiration date of June 22nd. We are not in a position today to take that plea.
Okay. So then I think what I will do is I'll go ahead and get this on the trial calendar and make sure we set a status in advance of that date. Let me take a look at my trial calendar. And let's see here. Mr. Collins, 3 days, 8 jurors.
Yes.
Mr. McCarty, let's see here. August 19th, are you available?
I am, Judge.
And Mr. Collins, do you know if Ms. Cheskis has any issues on August 19th?
None.
Okay. So, Mr. Lindell, I'm going to set 3 different dates for you, okay? I'm going to set a jury trial date for you. That's going to be on August 19th. It'll be here in this courtroom. Just pull up the August 19th. Again, we'll begin jury selection at 9. I'll meet with counsel at 8:30. I'm going to set a pretrial conference for you on August 3rd. And that will be at 1:30 in the afternoon. And then I'm going to set a status hearing. Mr. McCarty, I'm looking at either June 1st or June 15th. Do you have a preference?
The June 1st date would be great.
Okay. I'll set a status hearing for you on June 1st at 1:45 in the afternoon. So between now and especially that first date, you're going to need to have some contact with Mr. McCarty to talk about the plea offer. If you don't accept it on that date, I will most likely do a downward advisement so that we can make sure we're moving forward. If you fail to appear for any of those hearings, a warrant could issue for your arrest. If you fail to appear for the trial could go forward in your absence. Do you understand that, sir?
Yes.
Okay. Mr. McCarty, anything else then on Mr. Lindell's matter?
No, Judge, thank you.
Mr. Collins, anything else?
No.
Okay, Mr. Lindell, that's all today. Thank you.
Just take it on. Okay, thank you. I'll email you and stuff.
Sounds good.
Thank you.
Is Miss Gaskill out there?
Yeah, I didn't see her.
Do you want to make a call, Mr., well, I guess we're still right on time, but do you want to maybe make a phone call? You can stay right where you're at. Yeah, see, you don't have a cane today. Does that mean you're doing better at least?
I'm feeling better. Still hurts, but the cane's more trouble than it's worth.
Okay.
You sure?
We can go off the record. It'll be a couple minutes. Okay, we'll go on the record. Okay, we're on the record in State versus Adler, CR 2022-223. I'll note Mr. Adler is present out of custody, represented by Mr. McCarty, who's here, Mr. Collins, Chief Deputy from the County Attorney's Office. We're here for a status hearing today. I'll note that there is currently a jury trial set in June and a pretrial conference set in May. Mr. McCarty, any updates today from the defense?
Judge, the intent was to get a settlement conference set in this case, but I've struggled to get in contact with Mr. Adler. He has called me, but when I return his call, for some reason, my messages go straight to voicemail, and it says it can't take a message. So I have him here today, and I'm hoping to get this set for a settlement conference. But other than that, we're simply going to, I guess, for today, affirm the dates that we
Okay.
have.
And so your plan is, after you're done with your hearings today, you're going to reach out to Ms. Guadiana and work on trying, while he's still in the building, get that set?
That's exactly right.
Okay. So, Mr. Adler, make sure, even after you're done with me today, that you stay here until Mr. McCarty gets you a date potentially of another hearing, okay?
Okay, thank you.
The two dates that I will tell you are on the calendar are May 18th, which is the final pretrial. Let me just verify what date that is, what time that is. May 18th at 1:30 here in Payson, and then June 10th at 9 a.m. here in Payson. Those are the two dates we got going. You're going to get another date probably in front of Judge Cannon between now and then, okay?
June 10th, what time?
The jury trial's at 9, okay? Mr. Collins, anything the state would like to add today?
No.
Okay, Mr. McCarty, one other thing I will ask is if the matter's not resolved and we're back at the pretrial in May, if you can have discussed with Ms. Evans how you want to address the prohibited possessor charge, whether the two of you step to a total bifurcation, whether we can do a Part A, Part B of the trial, or just whatever. I'd rather have the two of you try to work that out rather than having me make that decision.
Understood, Judge, thank you.
Okay, okay, that'll be all then today, Mr. Adler. And maybe, Mr. McCarty, if you even want to take a moment now and try to reach out to Ms. Guadiana before our next matter, let's do that. That way Mr. Adler can get on his way sooner rather than later. Yes, yeah, just affirm May 18th and June 10th. And if you could just note that they're going to get to work on a settlement conference. Excellent. Thanks for your help today. Appreciate it.
I would have known I wouldn't be in jeans.
I am just grateful that you're here. It was a last minute thing when Mark was unavailable. Okay, we'll go on the record in the Gaskill matters. There are two of them. CR 2025-435 and 436. I'll note Mr. Gaskill is present out of custody, represented by Mr. McCarty. Mr. Collins, Chief Deputy from the County Attorney's Office, is present. We're currently set for jury trial on the 435 matter for May 6th. I note Mr. McCarty has indicated that he is not ready for trial. And I'll let the parties know that ahead of you on the calendar is the Taylor matter, which I think Ms. Ormond and Mr. Van Auker have both indicated they're ready to go on that. Mr. McCarty, can you give me an update on where we stand today?
Yes, Judge, I got a revised plea offer from the state late last week that's got an expiration date of today. Had an opportunity to talk to Ms. Gaskill about it. We're not in a position to accept it. I'm going to make a deviation request to Ms. Ortman in this case to see if there's another potential resolution to resolve both of these cases. Also, Ms. Gaskill advised me that she pled guilty in Payson Justice Court. And when I looked at the plea, I was trying to correlate the plea to the DR numbers. I may be making a motion to dismiss these cases.
Okay. So it sounds like what I hear with that information, Mr. Collins, I'll go hear from you in just a moment, but I'm inclined to vacate the May 6th trial, both because the defense isn't ready and also because I have a trial ahead of it. Reset the matter for May 18th for a new trial setting conference. I think we probably should do a Donald advisement today if there is a new plea that expires today. And then in the interim, Mr. McCarty, you can circle back to Ms. Ortman and or file motions as may be necessary. So, Mr. Collins, do you have any objection to that process?
No.
Mr. McCarty?
No, Judge, thank you.
Okay, so Madam Clerk, I'm going to vacate the trial that's set for May 6th. Let me see here. So Ms. Gaskill, and then there's a status hearing too, I believe. The trial is set in the 435, so we'll vacate that and the status hearing in 436. I'm going to reset both of them for May 18th for a trial setting conference. That'll be at 2 o'clock in the afternoon. So Ms. Gaskill, the next time I'll see you is on May 18th, in this case at 2 o'clock in the afternoon, okay? Continue to stay in touch with Mr. McCarty. I don't know what's going to transpire between now and then. Okay? Time will be deemed excluded between the current trial date and the next trial date as may be necessary. Ms. Gaskill, because there's a new plea and it expires today, we're going to go through a Donald advisement. I think we've done this once before with you. So I just want to make sure, probably I think what we can do today is just put on the record what the new plea is, since we've already gone through what could happen at prior hearings. Mr. McCarty, do you have any objection to that?
I do not, Judge, thank you.
So what's the current plea offer?
So the current offer is in the case ending in 435. Ms. Gaskill would plead guilty to count 1 as amended to child abuse as a Class 6 felony, as a domestic violence offense. In the case ending in 436, she would plead guilty to count 1 as amended aggravated assault as a Class 5 felony. In the 430 case ending in 435, she would be placed on probation for a period of time to be left to the court. As a term of probation, she would complete the Life Skills and Wise Choice Alternative Program and pay a variety of fines and court fees. In the case ending in 436, she would also be placed on probation for a period of time to be determined by the court, but she would also be sentenced to 6 months in the Gila County Jail, in addition to any credit for time served, and that sentence would not be deferred or suspended upon completion of probation.
So 6 months in addition to whatever she's spent.
That's how I read it.
Okay.
I thought it was the other way around.
What's that?
I thought it was the other way around. She would get credit for time served, not in addition to. I don't have it in front of me.
It says 6 months in addition to any credit for time served.
Okay.
That's how I read it anyway, that she wouldn't
Okay.
burn time.
Okay, so Ms. Gaskill, you understand that's what the current plea is today. You understand that Mr. McCarty can reach back to Ms. Ortman and ask for a different plea, but there's no guarantee after today that that's available. You understand that?
Yes,
Okay, and as of today, you do not wish to take that?
yes.
Okay. So, ma'am, I'll see you back on May 18th. I think I set that at 2 o'clock in the afternoon. Okay, that'll be all today, Ms. Gaskill. Thank you.
Okay, thank you.
And I vacated the trial, yes. Okay, good. Okay.
Okay, let's see.
Okay, we'll go on the record in State versus Morris, CR 2025-403 and 404. I'll note that Mr. Morris is here in the courtroom. His attorney, Mr. Green, is appearing remotely. Mr. Collins, Chief Deputy from the County Attorney's Office, is present. Mr. Green has emailed to the court a copy of the plea agreement that had all signatures on it. Mr. Green, I'm going to ask your client to sign in ink on, just so I have an ink signature of him. Do you have any objection to that?
Your Honor.
Okay, so sir, Mr. Morris, if you could sign that on the last page next to your signature in ink, and then if you give it to our guest, it's not Miss Boatwright anymore. What's the, what?
Jaconi.
Okay, I made a note on my different sheet. I knew I was wrong here. Can you spell it?
Taccone.
Tony. Okay, thank you.
Of course.
If you can give that to Mr. Taccone, and then you can trade him one back so he'll have a copy. Okay. And Mr. Green, you've discussed appearing virtually as your client enters the plea today with your client?
Yes, I had, Your Honor. We'd talked about me being there personally, possibly, but the option for virtual was also option. And because of a tragic event that happened this morning, I'm grateful for it. We don't need to get into that, but I will be there at the sentencing. We had a settlement conference with Judge Chambers, and we can go over the plea. This was well negotiated. The state, Ms. Richardson, Ortman, we handled the case very well together. So
Okay.
it's a good outcome. So maybe that's more than you wanted to hear, but
Thank you. And
sometimes
Mr.
you don't understand how much we appreciate it. Thank you.
Mr. Morris, I'm going to go through the plea with you. If at any point during our conversation you'd like to speak with Mr. Green in private, we can take a break, let you call him if you wanted to. It's not optimal that he's appearing remotely, but we can do it this way. I just want to make sure you have that option if you have a question as we move through. Okay?
Thank you, Your Honor.
Okay, can you pull the microphone a little closer to you? If you could tell me your full true name, sir,
Daniel Ray Morris,
and what's your date of birth?
9/16/89.
Okay, and how far have you completed in school, Mr. Morris?
I dropped out my sophomore year.
Okay, but you read and understand English without difficulty?
Yes.
Okay, have you had any drugs, alcohol, or medication of any type in the last 24 hours?
No, Your Honor.
Okay, I've been presented with a plea agreement, and you have a copy there in front of you. It indicates in the 403 matter, you're going to plead guilty to count 1 as amended, aggravated DUI, a class 4 felony, non-dangerous, non-repetitive, from May 20th of 2023, in violation of ARS 28-1383A1 and other statutes. It's non-dangerous, non-repetitive. In the 406 matter, you're going to plead guilty to count 1 as amended, aggravated DUI with a child present, a class 6 felony, committed on or about August 20th of 2022 in violation of ARS 28-1383A3A and other statutes. Again, non-dangerous, non-repetitive. Did you have a chance, Mr. Morris, to go over this plea agreement with Mr. Green?
Yes, Your Honor. I met with him and we went over everything.
Okay. And if I look on the final page, there's a copy of your signature and then you re-signed it again today. Is that correct?
Correct.
And prior to signing it, did you have the opportunity to review and understand the entire agreements?
I did.
And was Mr. Green able to explain it to you and answer any questions that you might have had?
Yes, Your Honor.
Has anyone promised you anything that's not in the agreements?
No.
Okay. Has anyone forced you or threatened you in any way to get you to enter the plea agreement today?
No, Your Honor.
Okay. Let me go over what the maximums are for a class 4 felony and a class 6 felony, and then we'll go through on page 2 specifically what you've agreed to. For a class 4 felony that's a DUI, you could get probation of up to 10 years. You could get 1 year in probation as a term of probation, 1 year in jail as a term of probation. You also could get up to 3.75 years in prison. The maximum fine is $150,000. For a class 6 felony that's a DUI, again, you could get 10 years probation, 1 year jail, up to 2 years prison, and again, the $150,000 fine. Do you understand those maximums?
I understand.
Now, I'm looking on page 2. It indicates in the 403 matter, probation is not available. You're going to be sentenced to the Department of Corrections for 1.5 years. You'll pay $500 to the cost of prosecution. You'll submit a DNA sample as is required for all felonies. The part about going into custody today has been crossed out, so you'll remain at liberty until sentencing. You'll pay a fine of at least $750, which is the statutory minimum. You'll pay $1,500 to the Prison Construction and Operations Fund, which is required by statute, $1,500 to the Public Safety Equipment Fund, also required by statute, $250 to the DUI abatement program, and your conviction will be reported to the Arizona Department of Motor Vehicles, and they may take administrative action towards your license. As to the 406 matter, in that matter, you're guaranteed probation. The court, myself, will determine how long that probation will be. You'll pay an additional $500 to the cost of prosecution. Again, you'll submit a DNA sample. Again, you'll pay the $750 fine, the $1,500 to the Prison Construction and Operations Fund, $1,500 to the Public Safety Equipment Fund, $250 to the DUI abatement fund. And again, the conviction will be reported to the Department of Motor Vehicles. And then I look on page 3 at the top. It indicates that all the remaining counts in each of these cases will be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
Okay. And if, as the sentencing judge, I found that the agreement we just talked about was inappropriate, I have the ability to reject it. If I did, I would give both you and the state an opportunity to withdraw. Basically, you could start over on the matter. Okay. Mr. Morris, are you currently on probation or parole anywhere?
No, sir.
Okay. I'm going to read you the citizenship advisory that I read to everyone who's in front of me on a change of plea. If you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a U.S. citizen. Mr. Morris, do you understand that once I accept your plea, you can't change your mind and withdraw unless it's necessary to correct a manifest injustice?
I understand, Your Honor.
And by pleading guilty, you give up certain constitutional rights. You're giving up your right to a jury trial, in which you could not be convicted unless the jury unanimously found you guilty beyond a reasonable doubt. You're giving up the right to confront and cross-examine witnesses who would testify against you. The right to have subpoenas issued for your witnesses so they could attend your trial and testify on your behalf. You're giving up the right to present other evidence on your own behalf and the right to testify at your trial if you chose to. At trial, you would also have the right not to testify, and if you chose not to, your failure to testify could not be used as evidence against you. You're giving up the presumption that you're innocent until proven guilty beyond a reasonable doubt. If you were convicted at trial, the jury would have to find, beyond a reasonable doubt, the existence of one or more aggravating factors before you could be sentenced to an aggravated term in the Department of Corrections. By pleading guilty, the court, not a jury, would decide whether aggravating factors exist. And finally, you're giving up your right to a direct appeal. Mr. Morris, do you understand all those rights?
I understand, Your Honor.
And do you understand that by entering a plea of guilty, you're not going to have a trial, so you'd be giving up those rights?
Yes, sir.
And you wish to do that?
Yes, sir.
And by pleading guilty, your only right of review of these proceedings would be to file a petition for post-conviction relief with this court. If that was denied, you could then ask the appellate courts of this state to review that denial, but there's no guarantee that they would take up that review. So, Mr. Morris, in CR 2025-403, count 1 as amended is aggravated DUI, driving impaired while your license was suspended, canceled, revoked, refused, or restricted from May 20th of 2023. How do you plead to that charge?
Guilty.
Okay. And in 2025-406, count 1 is as amended, aggravated DUI, being impaired while having a child present, a class 6 felony from August 20th of 2022. How do you plead to that charge?
Guilty.
And are you pleading guilty voluntarily and on your own?
Yes, Your Honor.
Okay. I'm going to ask Mr. Green to provide a factual basis or a short summary of what happened in each of these matters. After he does, I'll ask you if you agree with him. So, Mr. Green, can you first provide a factual basis for the 403 matter?
Yes, Your Honor. On or about May 20th, 2023, while Mr. Morris's driver's license or privilege to drive was suspended or restricted, he was found driving. He was stopped for a traffic violation. At that time, there were field sobriety tests done, and during that particular case, there was, let me get to the part, because we have two separate breath and blood.
I think it's an impaired
There was a
charge.
blood test done. There was a blood test done, and the blood was tested over 0.08. It was a 0.106. So he was impaired to the slightest degree at the time while driving with a suspended license. Thank you.
Is that correct, Mr. Morris?
That's correct.
Mr. Collins, any additions or corrections to that factual basis?
No.
Okay, and Mr. Green, can you provide a factual basis for the 406 matter?
Yes, Your Honor. On or about, let me get to the right date. August 20th, 2022, Mr. Morris was stopped for traffic violations. There were multiple children in the car that were under the age, and at that time there was impairment that was shown by field sobriety tests, and there was a breathalyzer test taken, and it showed that there was impairment to the slightest degree. I think it was 120133.
Okay. And the children in the car were under the age of 15?
Correct.
Is that correct, Mr. Morris?
That's correct.
Mr. Collins, any additions or corrections?
No.
Court finds that the defendant's plea is knowingly, intelligently, and voluntarily made. There's a factual basis for it. The court accepts the plea and enters it of record. The court will defer acceptance of the terms of the plea agreement until sentencing. Madam Clerk, I'll provide that to you. Mr. Green, looking at May 18th for sentencing, do you have availability here in Payson?
I'm going to look, Your Honor, but the one thing that we wanted to ask is Mr. Morris has some businesses to wrap up, and we were going to ask the court for 45 to 60 days. Ms. Ortman didn't, at the time, during the settlement conference, have any objection to that, but I didn't have a specific date. So I don't know if it's possible to go out a little further than May 18th to let him wrap up the issues that he's got. And if you want to do a sentencing on Monday,
Let me,
a little further out.
Mr. Collins, does the state have an objection if I move this out about 45 days?
I don't see a note here one way or the other. so-
Okay. Mr. Green, you said there was a settlement conference in this case. Which of our judges did that? Was that Judge Cannon?
Judge Chambers.
Okay, and do you know did Judge Chambers do that because Judge Cannon had a conflict? And the reason I ask is Judge Cannon is covering my June 1st calendar.
I don't know why we got to Judge Chambers. He was available. We tried to get multiple
Okay.
dates.
That's probably
And
why.
I can't remember exactly how we got to Judge Chambers, but one of the options possibly was to waive it before you, but we were trying to find appropriate dates, so it took a little bit of time.
So June 1st, are you available? That's about 45 days out.
I am available that day, Your Honor.
Do you prefer a morning
And
or
if you wanted-
afternoon setting?
Morning, if we could.
Okay, so 9:45, will that work for you, Mr. Green?
That's fine with me if it's okay with Mr. Morris.
Mr. Morris, June 1st at 9:45?
Yeah, that'll work.
Okay. So, Madam Clerk, I'm going to set this for sentencing June 1st at 9:45. I'll order that a pre-sentence report be prepared. Mr. Morris, before you leave today, Ms. Leonard is going to give you a packet of information. She's from our probation staff to fill out. That way our probation staff can write me a report, or Judge Cannon. So if you can take a few minutes after we're done with court to fill that out. If you have a question about anything, I'm sure Mr. Green could take your call quickly. I don't think there'll be anything in there that should cause that, but if you need to, you can. I will see you back on that date. Make sure on that date you have your affairs in order and are prepared to be taken into custody, or Judge Cannon will, one of the two of us. If you fail to appear for sentencing, a warrant could issue for your arrest, and also the guarantee of probation on the second matter goes away, and also the probation or the guarantee of a mitigated sentence on the first matter goes away. So it's essential that you're here. If an emergency arises, you can reach out to Mr. Green, and I'm sure he can advise you on that. Okay, Mr. Green, anything else this afternoon?
One question, Your Honor. We did do a settlement conference memo. I don't know if you can review that. It would be, in essence, the reasons that, give you a good explanation of the case. I could turn it into a sentencing memo, but I didn't know if you can review it or not.
They're usually not completely recorded, counsel, so
It looks like it may have actually been filed.
did they
in this
record the
matter.
whole thing?
Looks like they,
No, just my memo. Just my
Yeah,
memo,
Just
Your Honor.
memo.
but 5 pages, right? 5-page memo?
Yeah, that's it.
I thought he
Okay.
was talking
I'll
about the
reference that.
conference.
Would you like me to forward that to our pre-sentence writer? Or actually, let's
Yes,
just
Your
do
Honor.
this. Ms. Leonard, if you could note that on April 1st, the defense submitted a settlement conference memo, and if you could have Ms. Smith review that as potential mitigation in the case. Okay? Okay.
Thank you, Your
Thank you, Mr. Green. That'll be all then today, sir. Make sure you get with Ms. Leonard.
Thank you,
before
Ron.
go.
Thank you. Thank you, Your Honor. Thank you,
Okay.
Joe. I'll call you soon, Joe. Thank you.
Okay. Did Nikki text you back or chat you back? Okay, thanks. See here. Brubaker. Becky. Okay, and I think you filed a motion to have her appear remotely. I don't see it. Okay, can we bring in whoever's in the waiting room? Okay. Matter is State versus Shelley, CR 2026-92. I'll note that Mr. McCarty is here on behalf of Mr. Shelley. Mr. McCarty had filed a motion either yesterday or early this morning asking that his client appear remotely. I don't see him yet, but I'll hear from Mr. McCarty on that. I'll note Mr. Collins, Chief Deputy from the County Attorney's Office, is present. Mr. Collins, could you let me know who this is assigned to within your office?
Ms. Ortman?
Okay. And Mr. McCarty, can you give me an update on if you know where your client is today?
So, Judge, I'll be brief. I thought Mr. Shelley was in the Arizona Rehab Campus in Tucson. My understanding, and I went out to call him, my understanding is that he is no longer there. He was discharged from that facility. In checking my voicemail, apparently I received voicemail yesterday on Sunday. Couldn't hear it, so I dialed the number back. It's El Dorado Rehab Facility. So I have left a message there. They can neither confirm nor deny that Mr. Shelley is there. However, I left a message indicating that it was urgent, and they stated they would route it appropriately. So I can tell you that Mr. Shelley has maintained good contact with me since I was appointed to represent him. I've received emails and phone calls from both him and the facility he was at in Tucson. But something must have happened over the weekend where he is now in a different facility. At least, I suspect that's where he's at. I can't prove it.
Mr. Collins, what's the state's position given the information Mr. McCarty has presented?
We'd request a warrant, Your Honor. ACIC 2500.
And Mr. McCarty, given the fact that your client has been in good contact, but you don't have current contact information, I'm inclined to issue a warrant. This is a non-victim matter. If he self-surrenders, then I would look at putting him back on an OR release. Would you like to be heard?
Just briefly, Judge, my understanding is that he was in a treatment facility. I have no reason to believe that he would not be in the one that I called. I can't imagine who would have called me otherwise from that number. This is an aggravated DUI case. My request would be to set this out another week so I can find out, exactly where he is. There's no harm to anyone doing that. If he has a warrant and he's discharged from that facility, that is going to be a real problem for him.
Madam Clerk, if you could note the state asked for a warrant today. I'm going to defer ruling on that for 2 weeks. I'm going to reset this matter for May 4th at 2 p.m. for a continued trial setting possible change of plea. Mr. McCarty, if you do not have additional information on your client's whereabouts, I will issue the warrant at that point, but I think by the time I get the warrant issued and if your client gets back to you, we're just going to spin wheels there. So.
I understand, Judge. And just so the court's aware, that there's a plea offered. It doesn't expire until May the 18th.
Okay. Okay, that'll be all then on Shelley.
All right, thank you.
Thank you. And then, Mr. McCarty, that was your last one till 3:30?
It is, Judge.
Okay. Okay, yeah, let's, if she wants to have a seat in the back, is she in the courtroom? Okay, is that her on the?
Or no, sorry.
Yeah, just have her have a seat in the courtroom. I'm going to call her case in a few minutes. Okay, Ms. Ormond, if you want to come on in, we'll do the Taylor matter next. Okay, next matter is State versus Taylor, CR 2025-378. I'll note Ms. Taylor is appearing remotely as the court previously allowed her to do. Ms. Ormond, her attorney, is here in the room. We have Mr. Van Auker, who's appearing remotely. This matter is currently set for jury trial on May 6th. I'll note that there is a motion to suppress that is pending. I'll note also that after the motion to suppress was filed and I was looking at the trial priorities, both parties had indicated that they're ready to go, but for the motion, I had had my JA send out the possibility of addressing the motion this Friday, and then that way we could move forward with the trial, assuming that I do not grant the motion. If I affirm the trial, grant the motion, then obviously that'd be vacated potentially. So, Ms. Ormond, your client is ready to go to trial, and I think you were available this coming Friday at 3:30 for, or actually, yes, this Friday at 3:30 for a motions hearing?
As for the motions hearing, yes, Your Honor, we are ready to proceed. It was my understanding that the court would allow everybody, all the parties to appear virtually. I think that in light of the fact that my client just gave birth, that accommodation would be necessary. The state and the defense have also, we'd like to get a settlement conference. We'd like to explore methods of resolution just short of trial. I don't know if the state, I'm hopeful, considering the
Mr.
circumstances.
Van Auker, we're getting a lot of background noise on your side.
Van Auker? I'm on.
Okay, Ms. Ormond, you can continue.
I'm hopeful that considering the circumstances in that my client just gave birth, that the state would allow the plea offer to remain open. My client would much rather explore a pretrial resolution than to have to take this to trial. So also, I just wanted to note for the record that at the time that the defense had filed their trial readiness, the evidence had not yet been available. And so the timing of these different, the trial readiness notice and the motion to suppress, it's all a little bit awkward. So I'm hopeful that we can get a settlement conference going before Judge Cannon in the near future. And secondly, if the state would be open to keeping the plea offer open, considering my client just gave birth.
So are you still ready for trial, though, on the 6th?
Yes, Judge.
Okay. And Mr. Van Auker, is the state still ready for trial?
The state is, Your Honor.
Okay. And, okay, and are you, I think what I'm going to do is let you and Ms. Ormond speak offline about whether the plea will remain open or what that is. Okay, and Mr. Van Auker, the April 24th at 3:30 will work for you and the officer?
Yes, Your Honor.
Okay. So, Madam Clerk, I'm going to do several things, and I'm making some notes. I'll give you my notes since I'm going to do quite a few things. I'm going to set a motions hearing for this Friday, April 24th at 3:30. That will be on my Payson calendar, but all parties, counsel, and the witness can appear virtually at that hearing. I'll order that case lines be opened so that if any exhibits need to be uploaded, they can. I'm going to affirm the May 6th trial that's here in Payson. I'm going to set a hearing on May 4th at 3:45 to review jury questionnaires. I'm going to order that jurors be summoned. I'm going to ask Mr. Van Auker, Ms. Ormond, if you could please potentially come up with a summary of the case that goes in our jury questionnaire and get that to Veronica no later than noon tomorrow. The key things I would ask is if you could make sure that the location, specifically the location where the events are alleged to have been committed, are in there. It's always helpful to our jury pool if they know it was in the 400 block of East First Street or something like that, just so they know if they saw lights or sirens in their neighborhood, or they can do that. So, okay, and so I've affirmed that. Okay. Ms. Taylor, I will see you virtually on Friday for that hearing. Okay, that's at 3:30 in the afternoon. If it's not resolved there or at a potential settlement conference, I'll see you here in Payson on May 6th. We'll begin our trial at 9. I'm going to be meeting with the attorneys at 8:30. You can be here at 8:30 if you choose to. If you fail to appear for the trial could go forward in your absence. Do you understand that, ma'am?
Yes, Your Honor.
Okay, and then we have that hearing, the jury questionnaire review hearing, which is set on May 4th at 3:45. I'll let you talk to Ms. Ormond. You're free to be at that hearing. Ms. Ormond, you're free to waive your client's presence at that hearing if you choose to.
Thank you.
Okay. Ms. Ormond, anything else then on Ms. Taylor today?
Nothing on Ms. Taylor.
Okay, and Ms. Taylor, if Ms. Ormond is able to get a settlement conference, it's going to be on a really short turnaround. It sounds like you've been very responsive to her. Make sure you're ready, though, if that's necessary. Mr. Van Auker, anything else on Taylor?
No, Your Honor.
Okay, Madam Clerk, you're good. I did a lot of things there. We should be good. Okay, thank you, Mr. Van Auker. Thank you, Ms. Taylor. That'll be all.
Thank you.
Okay. Let's see here, just a second. Okay, there we go. Let's see. Is Mr. Cook here? Mr. Cook, why don't you come on up to the table? Let's see here, and where did I go? Is Ms. Talon here? Yes. Okay, and Ms. Talon, I'm going to do this matter, and then I'll call your matter next. Okay. So, Counsel, after we do the Cook matter, I have a family law matter that I need to add on, and I need to ask everyone just to step out briefly. We'll go ahead and use that as our afternoon recess. Okay, next matter is State versus Cook, actually three matters, CR 2026, 40, 43, and 56. I'll note Mr. Cook is present out of custody. He's represented by Ms. Ormond. Mr. Collins, Chief Deputy from the County Attorney's Office, is present.
Your Honor,
Yes.
apparently I have a conflict.
Okay,
I'm not aware of it, but
okay,
I guess we need to get Ms. Hamlin to handle the
okay.
hearing.
Do you know that you don't even know the nature of it right off, do you?
I'll be honest, I don't.
Okay. Ms. Ormond, can you give me an idea of where are we going? Well, let's just do this. I need to handle that family law matter.
Sure.
So I'm gonna set this matter aside, Madam Clerk. If I could have everyone, we're gonna take a recess on the criminal matters until 3:15 or shortly thereafter. Sir, when we come back at 3:15, you'll be first on my list. And if I could have everyone except for Ms. Talon and any people that she has with her, and then Ms. Talon, if you want to make your way up to the table here. Okay? And I'll see everyone back about 3:15 then.
We all need to step out.
Yes, please. You can leave all your things, though. We'll have nobody at your table.
It's easier said than done.
Okay, here.
Hi, good, how are you? You can come up here.
It's probably better if he just stays right there.
Oh, that's fine.
Yep.
Okay.
You're just going to use her profile, or are you going to change out? Okay, and let's
Connie Brewer.
Okay, Ms. Brewer, so I'm going to do Ms. Brewer, and then Mr. Bednar, I'm going to do the Young matter next, and then we'll circle back to Ms. Ormond's other matters. Except we need to have Ms. Hamblin, which was the conflict matter?
Cook.
Okay, I'm sorry. Ms. Brewer, I'm going to ask you to have a seat back. Mr. Cook, if you want to make your way up, I'm sorry, I got a little discombobulated there. I'm like, wait, why is Ms. Hamblin here? Now I know. Okay. Close this down. Okay, we'll return to the record in State versus Cook. It's our 2026 40, 43, and 56. I'll note Ms. Hamblin is now with us from the County Attorney's Office. And again, Mr. Cook is here and Ms. Ormond is here. Ms. Ormond, we're here for a trial setting conference today. Can you give me an update on where we stand?
Yes, Judge. The state has offered a plea with an expiration date of June 22nd. So at this point, my client and I are planning on setting a date and a time to review the evidence together and to determine whether or not we will be accepting the terms of the plea. So we would probably just select some trial dates to keep this case moving forward.
Okay. Okay, and Ms. Hamblin, this is Ms. Evans' matter, is that correct?
That's correct.
Okay. Okay, then I am going to look, and Ms. Hamblin, if looks like the 2643 is the oldest case, or first in time, and so I would set that one for trial. Does that sound correct?
Let me see.
And Ms. Ormond, does it sound, is the 43 matter, does that seem like the oldest or first in time of the alleged violation date?
Yes, from the state side, Your Honor.
Okay.
Correct. That
Okay.
was in 2022.
And so, Ms. Ormond, I'm looking at potentially August 19th for a trial on that matter. Or do you have any calendar conflicts you're aware of?
Not that I'm aware of.
And Ms. Hamblin, any notes of Ms. Evans being unavailable on August 19th?
No notes stating that, Your Honor.
Okay. So, Mr. Cook, I'm going to set 3 different dates for you. First is going to be a jury trial in the 2643 matter. That's going to be on August 19th. We'll begin jury selection at 9. I'll meet with the attorneys at 8:30. As of right now, I'll plan on that being 3 days and 8 jurors. I'm going to set then a pretrial conference date, which let me take a look back here. Where are we at? August 18th. That's going to be on August 3rd. That'll be here in Payson, and that will be at 2:30 in the afternoon. And then finally, I'm going to set a status hearing. Ms. Ormond, do you have a preference, June 1st or June 15th?
No preference.
Okay, I'll set that on June 1st at 2:30 in the afternoon. Will be a status.
2:30, Your Honor?
2:30, yes. Okay, and then finally, I am going to go ahead and set a trial readiness notice hearing as well. That would be on the July 21st. And that'll be at 1:30 on my Globe calendar. So, Mr. Cook, you don't need to worry about the trial readiness notice hearing, but you do need to be ready. The status hearing, you'll need to be here, and that'll be pretty close to the plea expiration date. So if you want to take the plea, you'll need to take it by that date. And then the pretrial conference date and the trial date. If you fail to appear for any of those dates, a warrant could issue for your arrest and new charges of failure to appear could be filed. If you fail to appear for the trial and we're on trial track, the trial could go forward without you. Do you understand that?
Yes.
So, Madam Clerk, the dates I just set will all be for the 2643. And then if you could, on the status conference, on the pretrial and the jury trial, if you could set statuses in the 40 and the 56 matter. Not on the TRN date, though. So the July 21st date will only be for the 43 matter. All the other dates are going to be for all 3 cases. Okay? Okay. Ms. Hamblin, anything else on the Cook matter?
No, Your Honor.
Ms. Ormond, anything else on Cook?
No, Judge.
Okay, that'll be all today, Mr. Cook. Thank you. And then, Ms. Brewer, if you want to make your way back up front, I have you come back up now that we're really ready. Okay. Okay, next matter will be State versus Brewer, CR 2025-500. I'll note that Ms. Brewer is present out of custody. Ms. Ormond, her attorney, is here. Ms. Hamblin is here from the county attorney's office. This is a final pretrial conference. This matter is currently set for trial on May 13th. I'll note that I've already affirmed 2 trials above this case on the calendar. I'll also note that Mr. Alcorn had filed a notice that the state was not ready. I believe he may have filed a motion to continue. Let me just take a look. Yes, he did file a motion to continue. Ms. Ormond, again, most likely to continue this because of congestion on the court's calendar, but can I get your formal position on the motion to continue?
No objection, Judge, and in fact, that's actually probably favorable because there's a couple of other discussions I need to have with Mr. Alcorn, so no objection.
Okay, and so, Madam Clerk, I'm going to vacate the jury trial that's currently set for May 13th. Ms. Ormond, if you're going to be having additional discussions, if I just set this for a trial setting conference in 4 weeks, and that way you can make sure that, have those discussions and we'll determine if we are on the trial track still?
Sure.
Okay. Ms. Hamblin, Mr. Collins, any objection if I just reset this for a trial setting on May 18th?
No objection, Your Honor.
Okay. So, Madam Clerk, I'll set this for a trial setting conference May 18th at 2:45 in the afternoon. So that's the next time I'll see you, ma'am. Between now and then, continue to stay in touch with Ms. Ormond, as I'm sure you have. As I've told you before, if you fail to appear, a warrant could issue for your arrest. New charges of failure to appear could be filed. Ms. Hamblin or Mr. Collins, who is this assigned to? I had Mr. Beckwith, but it's not him anymore, I'm sure.
It's Mr. Alcorn.
Okay. I'll note Mr. Alcorn is the assigned prosecutor. Okay. Then that'll be all today, Ms. Brewer. Thank you. And Ms. Ormond, I'm going to have Mr. Bednar and his client come on up. Do theirs. Okay, Nance. Oh, good. Okay. Thank you. Nance.
Judge, can I approach?
Yes, please do. Excellent. Okay.
On the plea numbers for the testimonial, I'm not sure what's that right now, or should I file that under seal?
I think I'll take it today and ask that the clerk file it under seal. No idea. Just take a look. Okay. What does it say? Any part of that means actually. Okay. Okay. Next matter will be State versus Young, CR 2025-454. I'll note that Mr. Young is present out of custody, represented by Mr. Bednar. Mr. Collins, Chief Deputy from the County Attorney's Office, is present. Mr. Bednar, have been presented with a plea agreement. Your client wishes to move forward with that today?
That's correct, Your Honor.
Okay. Mr. Young, can you tell me your full true name, sir?
Christopher Joseph Young,
And what's your date of birth?
June 6, 1978,
Okay, and how far have you completed in school, sir?
high school.
So you read and understand English without difficulty?
Yes,
Okay. Have you had any drugs, alcohol, or medication of any type in the last 24 hours?
just my medication.
Okay. And anything about that medication cause you difficulty as you met with Mr. Bednar before court today?
Yes.
No. Did it cause you difficulty?
No,
Okay. Didn't want that to be a trick question, just wanted to clarify. And you're having no difficulty understanding me now? You can understand me fine?
I think so, yes.
Okay. I've been presented with a plea agreement. It indicates you're going to plead guilty to count 1 as amended, conspiracy to transport dangerous drugs for sale, a Class 2 non-dangerous, non-repetitive felony from July 28th of 2022 in violation of ARS 3407A7 and other statutes. It also indicates you'll admit 1 aggravator, which is the presence of an accomplice. Did you have a chance to go over this written plea agreement with Mr. Bednar?
Yes,
And if I look on the last page, page 5, is that your signature on page 5?
correct.
And prior to signing the agreement, did you have the opportunity to review and understand the entire agreement?
Yes,
Was Mr. Bednar able to explain it to you and answer any questions that you might have had?
yes, correct.
Has anyone promised you anything that's not in the agreement?
No,
Okay, has anyone forced you or threatened you to get you to enter this plea agreement?
no.
Okay, let me go over what the maximums are for a Class 2 felony, and then we'll talk about what's on page 2, what you've agreed to.
Okay,
So the maximum for a Class 2 felony, you could get up to 7 years probation, 1 year jail, up to 12 and a half years in prison, and up to a $150,000 fine. Do you understand those maximums?
yes,
Now, I'm looking at page 2 of your agreements, and it indicates, and this is about line 16, it says you'll be sentenced to a period of probation, supervised probation for 36 months. You'll pay $750 for the cost of prosecution. The state will not be requesting any upfront jail time. You'll pay a $20 court security assessment. You'll abide by the terms that are outlined in Exhibit A that I will be filing with this. As a term of probation, you'll complete the Wise Choice Alternatives program, and then you also will complete any requisite counseling, et cetera, as directed by the probation staff. Counsel, I'm looking on page 3. Is this an offense that would require reporting to MVD with revocation, or is that from some other?
Yeah, Judge, I think that's a typo.
Okay, Mr. Collins, on page 3, do you have any objection if I cross out about this being reported to motor vehicle? It appears to be from a DUI form.
Yeah, no objection.
Okay, so I'm going to cross that out. Okay, and then, Mr. Young, it indicates then that counts 2, 3, and 4 will all be dismissed. Is that your understanding of the agreement?
correct.
If I found that the agreement we just went over was inappropriate, as the trial judge, I have the ability to reject it. If I did, I would give both you and the state an opportunity to withdraw, and basically you could start over again. Okay. Are you currently on probation or parole, Mr. Young?
I am not.
Okay, I'm going to read you the citizenship warning that I read to everyone. I don't know if it applies to you, but if you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation, even if the charge is later dismissed. Your plea or admission of guilt could result in deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a U.S. citizen. Mr. Young, do you understand that once I accept your plea of guilty, you can't change your mind and withdraw unless it's necessary to correct a manifest injustice?
I understand.
Okay, by pleading guilty, you give up certain constitutional rights. You're giving up your right to a jury trial in which you cannot be convicted unless the jury unanimously found you guilty beyond a reasonable doubt. You're giving up the right to confront and cross-examine witnesses who would testify against you. The right to have subpoenas issued for your witnesses so they could attend your trial and testify for you. You're giving up the right to present other evidence on your own behalf, including the right to testify yourself. You would also have the right not to testify, and if you chose not to testify, that could not be used against you. You're giving up the presumption that you're innocent until proven guilty beyond a reasonable doubt. If you were convicted at trial, the jury would have to unanimously find, beyond a reasonable doubt, the existence of one or more aggravating factors before you could be sentenced to an aggravated prison term. By pleading guilty, the court, not a jury, would decide whether aggravating factors exist. And finally, you're giving up your right to a direct appeal. Do you understand all those rights, sir?
Yes,
And do you understand that by entering a plea, you're not going to have a trial, so you're giving up those rights?
yes,
Do you wish to do that? Give up the
Yes.
rights? Okay. And by pleading guilty, your only right of review of these proceedings would be to file a petition for post-conviction relief with this court. If that was denied, you could then ask the appellate courts of this state to review that denial, but such review may or may not be granted. Okay. Mr. Young, count 1 as amended is conspiracy to transport a dangerous drug for sale, a Class 2 felony from July 28th of 2022. How do you plead to that charge?
guilty.
Okay. And are you pleading guilty voluntarily and on your own?
Yes,
I'm going to ask Mr. Bednar to give me a short summary of what occurred leading to this offense, called a factual basis. After he does, I'll ask if you agree with him. Mr. Bednar?
Yes, Judge. And Judge, on July 28th of 2022, there was an officer welfare check conducted on the Forest Road, number 1006 in Pine, Arizona, which is within the jurisdiction of this court. Upon contact with Mr. Young and another passenger in the vehicle, the officers developed indicators of criminal activity, and then there was an eventual search of the vehicle. And during that search, Judge, outside of the vehicle, outside of one of the windows of the vehicle, several grams of methamphetamine were located, and inside the vehicle there was a scale that was also found that had methamphetamine residue in it. And the amount of methamphetamine that was found outside the vehicle would have been above the threshold level for sale, Judge.
Mr. Young, is that correct?
Yes.
Okay, and Mr. Collins, any additions or corrections?
No, Your Honor.
Okay. Court finds that the defendant's plea is knowingly, intelligently, and voluntarily made. There's a factual basis for it. The court enters the plea of record. The court accepts the plea and enters the record. The court will defer acceptance of the terms of the plea agreements. I'm going to order that the plea agreement be filed. I'll order that Exhibit A be filed under seal. So, Madam Clerk, Exhibit A. Mr. Bednar, looking at May 18th for sentencing, will that work for you?
Let me just pull it up real quick, Judge.
Yes.
Yes, Judge, at what time?
Do you prefer a morning or afternoon setting?
Afternoon would be great.
Okay, 3 o'clock.
Yes, sir.
So, Mr. Young is going to set sentencing for you May 18th at 3 o'clock in the afternoon.
Okay.
I'll order a pre-sentence report be prepared. You need to make sure you're here on that date. If you fail to appear for sentencing, the guarantee of probation you have goes away. So you could end up with jail or prison right off the bat if you fail to appear, okay? Before you leave today, Ms. Leonard is going to give you a packet to fill out. I'll ask you to take a few minutes while you're in the lobby before you leave to fill that out so our pre-sentence writer can prepare a report for me. If you have questions about what you should answer on that, I'm sure Mr. Bednar can take a few minutes to do that, or you can call him, okay? Mr. Bednar, anything else today?
No, thank you, Judge.
Mr. Collins, anything else?
No, Your Honor.
Okay, and let me just verify, I don't think we have any additional dates in this matter that I need to vacate, but let me do check that.
Judge, we...
Oh, we do have a jury trial,
we
don't
do,
we?
yes.
So, Madam Clerk, I'm going to vacate the June 15th pretrial conference, and I will vacate the July 8th trial dates. And then I'm going to make a note on here that I have a May 18th sentencing. Okay. Okay, that'll be all today, sir. Make sure you fill
Judge,
out... Yeah.
You also had a June 9th readiness date.
Okay, I'll also vacate the June 9th trial readiness date. Thank you, Mr. Bednar.
You're welcome.
I appreciate that.
All right, thank you.
Okay. Okay. And let's see, is Miss Nance here? Okay, why don't you come on up, ma'am? You'll be with, hopefully we got enough room for you to slide up. You can just be next to the table if you'd like to.
Oh, I'm sorry. Yeah, let me go ahead and...
If she's beside, wherever's most comfortable for her.
Okay.
Looks like she's not very
Okay
mobile
there?
there.
Okay.
So, yeah. Okay, that's fine. Yeah, no problem. Yeah, that'll work just fine. Okay. Next matter is State versus Nance, CR 2026-103. I'll note Ms. Nance is present out of custody. Represented by Ms. Ormond, Mr. Collins, Chief Deputy from the County Attorney's Office, is present. We're here for a trial setting possible change of plea. And let me start with you, Ms. Ormond. Can you give me an update on where we stand today?
Yes, Your Honor. A plea was extended with an expiration date of May 18th. Unfortunately, we were having some difficulty in communication. I think my client's phone was out of storage, something happened. So her and I do need some time to evaluate the offer, in addition to the evidence. So we anticipate having an answer by May 18th because that is the expiration date. I don't remember who's assigned to this.
Mr. Collins, I don't have a note who is either.
Ms. Ortman.
Okay.
Okay.
So I think with that being said, my client and I will need to get up to speed relatively quickly. So I think if the court just wanted to set some trial dates so we could keep this moving,
And
we
let
would
me
have no
ask,
objection.
Ms. Ormond, can I ask, is the plea a probation offer or prison?
Oh, gosh. I just looked at it this morning and I've already forgotten.
Because I'm looking at. looks like-
DOC.
It is a DOC office? Okay, then I think I will go ahead and get us on the trial calendar then. Okay. Ms. Nance, I'm going to set several dates for you. First, I'm going to set, the furthest out date is going to be a trial date, that if it's necessary, we'll have it on the
Your Honor.
calendar.
Ms. Ortman has indicated in her note, if trial is set, the plea will be withdrawn.
Ms. Ormond, would you like me to, you said May 18th is the deadline?
Yes.
I can do a short turnaround if you'd like. We can all come back on the 18th, and if the plea's taken, we can go from there. If not, we can do a downward advice.
Yes, Judge. Let's do
Okay.
that.
Okay, so Madam Clerk, I'm going to set this for a continued trial setting, possible change of plea, May 18th. I'll set that at 3 o'clock in the afternoon. So that's the next time I'll see you, ma'am. Make sure you're here. If you fail to appear, a warrant could issue for your arrest. Between now and then, you're going to need to have some intense conversations with Ms. Ormond about what your options are, okay? Sounds like as of right now, there's a deadline for that, so make sure you have that. Ms. Ormond, do you have good contact information for your client?
I do now, yes.
Okay, good. Okay, time will be deemed excluded between now and then. Mr. Collins, anything else on this matter?
No, Your Honor.
Ms. Ormond, anything else on Ms. Nance?
No, Your Honor.
Okay, thank you, ma'am. You're all done today. Oh. Okay, is Mr. Smith here? Why don't you come on up, Mr. Smith? Okay, next matter is State versus Smith, CR 2023-171. I'll note Mr. Smith is present, out of custody. Ms. Ormond, his attorney, is here. Mr. Collins, Chief Deputy from the County Attorney's Office, is present. This matter is set for a final pretrial conference, and we have a jury trial set on May 13th. Before I hear from the parties, I'm going to let the parties know what my current calendar is for the 13th. I've already affirmed 2 trials for the 13th, so I'm going to be asking Judge Chambers to do one of them. I'm going to be doing the other one. Both of them have their 2023 cases, just to give you an idea of how old they are. But I think Mr. Smith's case is, his has a 2023 number, but I don't believe he actually had arraignment till 2025. And so this case is substantially younger than them. There actually is still 1 or 2 other matters ahead of this. So unless something substantial changes, I'm going to have to bump this matter because of congestion of the court's calendar. So Ms. Ormond, with that introduction, do I just need to find another trial date as expeditiously as we can?
Yes, Judge, we intend to continue with trial.
Okay, and I think actually, Ms. Orma, I guess you're on the week before on trials, and then you don't have any this week. Mr. Collins, from the state's perspective, we're still on track for a trial?
Yes.
Okay. Let me see, and Mr. Collins, still looking 3 days, or could we do this potentially in 2 days? I'm trying to,
I don't know, Your Honor, it says 3 days, and without looking at the facts, I couldn't tell you.
okay. Ms. Ormond, you still, it's you and Mr. Alcorn, I think, so 3 days still sounds like a reasonable estimate?
I think we could honestly do it in 2, but I'd rather err on the side of having more time than what's needed.
Okay. Ms. Ormond, July 8th, I have some other cases, but I think you're going to, I don't have the exact arraignment dates, and, oh, I do have those. I think you're going to, let me just see, I think you have priority over most all of them. July 15th. You would have, there's only one older than you that day, if you'd like to do July 8th.
July 8th, does that work for you? Yes.
Okay. And Mr. Collins, I think Mr. Alcorn has several other matters already on that date, so it doesn't look like there's a calendar conflict there. Okay, so Madam Clerk, I'm going to continue the current jury trial date from May 13th. I'm going to set that out to July 8th. Let me just see here. We'll begin jury selection at 9. I'll meet with the attorneys at 8:30. 3 days, 8 jurors. And I'm going to set a final pretrial for us on, let's see here, June 15th, and I'll set that at 2:30 in the afternoon. Ms. Ormond, does your client reside here in the Payson area, or is he out of town?
He's out of town, Judge.
Okay. Would he like to appear remotely at that final pretrial?
Yes, please.
Okay, so I'll note that Mr. Smith may appear remotely at the final pretrial. I'm also going to set a trial readiness notice hearing for June 9th. That will be at 1:30 on my Globe calendar. Mr. Smith, you do not need to appear for that hearing. That's only for the attorneys to make sure they have their paperwork in line. Okay. So again, I vacated the May 13th trial, reset it to July 8th. Okay, Ms. Ormond, anything else then in this matter today?
Just a quick question for June 15th for the final pretrial. What time was that?
And I believe, let's see here, June 15th, 2:30, Madam Clerk, is that what I said? 2:30.
Thank you.
Okay, Mr. Collins, anything else?
No, Your Honor.
Mr. Smith, I apologize that we can't go forward with the currently set trial date. I'm sure you can understand. I have lots of cases, but we'll hopefully get you on the, move forward on the 8th. Okay, that'll be all today, sir. Thank you. Okay, is Ms. Bywater here? Why don't you come on up, ma'am?
Huh? Let me look. What's the name again?
Mr. Coney, can you just take a look in our lobby and then also go across the parking lot and just make sure we don't have anybody for our 3:30s? I suspect we don't, but. Okay.
No disclosure, no communication. Your choice. No, it's my case, so I said all that.
Is Ms. Bywater's now your Mr. Collins? Is your matter now?
Yeah.
Okay.
Did you do disclosure? I'm not seeing any.
Did I? Yeah.
I'll give you a moment to talk about it before I call it. Because
there it is.
Miss Ormond is the third attorney on the case. I think, right?
I think so.
You had Dean and Crawshaw?
Oh, am I
On. Mr. Collins, Chief Deputy from the County Attorney's Office, also the assigned attorney, is here from the County Attorney's Office. Ms. Ormond, can you give me an update on where we're at as of now?
Yes, Your Honor. When this case transitioned from Mr. Beckwith had presented an initial plea, but we understood that new charges were coming about, and they have. And so we were hopeful that we would be receiving a global plea to resolve all of the matters. I know this case has transitioned between multiple attorneys, and so it sounds like we just need a little more time to get that plea offer, and that's where we're at.
Okay, and so Mr. Collins, are you still, you plan on making a global offer that includes the 2026 matter?
Yes.
Okay. And Mr. Collins, if I move this out 4 weeks, do you think that's sufficient time for you to get that and get it to Ms. Ormond so she can review it with her
Yes.
client? Ms. Ormond, are you willing to waive time if I go out to the 18th?
Yes.
So Madam Clerk, I'll set all 4 matters for continued trial setting, possible change of plea on May 18th. That's going to be at 3:15 in the afternoon. So Ms. Bywater, that's the next time I'll see you. I'm hopeful that we can make some progress either towards a change of plea. Okay.
And I apologize to the court and counsel, I just missed the disclosure, so that's on me, and I apologize, and I'll get something out. Hopefully we can resolve it, if not, we'll definitely be ready for trial.
So Ms. Bywater, I'll see you back in 4 weeks.
Okay.
Make sure you stay in touch with Ms. Ormond. It sounds like in the next 5 to 10 days, she'll probably have some new paperwork for you. So make sure you stay in touch with her. If we don't have it resolved at the next hearing, I'm going to start scheduling them for trial, just so your case doesn't get lost.
Okay.
There's been a lot of bumps. It doesn't look like any of them are your fault. It's just we have attorneys that are changing on both sides, but I want to make sure they stay on track. Okay, and again, time is excluded, May 18th, 3:15. Just a trial, continued trial setting, possible change of plea. Okay, that'll be all today, ma'am. Thank you.
Thank you, Your Honor.
May 18th, 3:15. Okay.
I have someone on the Zoom line. If you can unmute your microphone for me. Okay, this is Judge Wright. Can you hear me?
Yes, sir.
And what's your name?
My name is Jacob Holmquist.
Okay. Okay, hold on just a moment, Mr. Holmquist. I'm going to call your case next.
Okay.
Okay. There we go, that's why. Okay, next matter will be State versus HomeQuest, CR 2026-169. I'll note Mr. HomeQuest is appearing remotely. Mr. McCarty, one of our court-appointed attorneys, is here on behalf of the Office of Indigent Legal Services. Mr. Collins, Chief Deputy from the County Attorney's Office, is present as well. Mr. Holmquist, this is the date and time set for arraignment on a Gila County grand jury indictment. You have the right to remain silent. You also have the right to be represented by an attorney. Mr. Holmquist, were you served with a copy of the indictment?
No, Your Honor.
Okay, and how?
Well, I believe my. Sorry.
Go ahead.
I believe my mom got a copy of them in the mail. But I'm currently in a treatment center in Prescott Valley right now.
Okay. And do you have?
But she did send me pictures of them.
Okay. Do you have? Do you know when you're going to be discharged from the facility there in Prescott?
Right now, my discharge is May 5th. That'll be 90 days.
Okay. Okay. Here's what I'm going to do. First, I indicated you have a right to be represented by an attorney. Mr. Holmquist, do you have any money to hire an attorney?
No, Your Honor.
Do you have any assets, car, house, stocks, bonds, anything you can sell and use that money to hire an attorney?
No, Your Honor.
Okay, I'm going to find that you're indigent for the purpose of this matter. I'm going to appoint an attorney. I'm going to appoint Ms. Ormond to represent you. And I'll note Ms. Ormond is here in the courtroom today. Mr. Holmquist, do you have a pencil and paper you can write down her contact information?
Yes, I do.
And Ms. Ormond, can you provide him with a phone number or whatever you prefer?
Are you ready, sir?
Yes, ma'am, I'm ready.
Okay, 602-292-9319.
9319.
Okay.
Okay.
Okay, and Mr. Collins, has this been assigned within your office?
Ms. Cheskis.
Okay. I'm going to continue out arraignment because I want Mr. Holmquist to be able to be here and also have a copy of the indictment in front of him. I'm going to continue arraignment to May 18th at 3:15 in the afternoon. So, Mr. Holmquist, you should be out of treatment by that point. You'll need to be here in Payson May 18th at 3:15 in the afternoon. Do you understand that?
Yes, Your Honor.
Okay, if you fail to appear for that hearing, a warrant could issue for your arrest or new charges of failure to appear could be filed. Do you understand that?
Yes, Your Honor.
Okay. Do you have a cell phone that you'll be using once you get out of treatment?
Yes.
Okay, can we get that number for Ms. Ormond?
Yes, it's 361
361
319
319
0229.
0229. Is that correct?
Yes.
Okay, Ms. Ormond, you got that number?
I did.
Yep, that's correct.
Okay, so Mr. Holmquist, I'll see you on May 18th at 3:15 in the afternoon here in Payson. You can feel free to reach out to Ms. Ormond in the interim. It may take her a few days to get your paperwork. So if you call her tomorrow, I'm sure she'll try to talk to you, but she may not have any paperwork, so you may just want to wait a week or two. Okay.
Okay, sounds good.
Ms. Ormond, anything else you want to add on this matter?
Nothing
Thank
further,
you.
Your Honor.
Mr. Collins, anything else on that matter?
No, Your Honor.
Okay, thank you, Mr. Holmquist. Have a good rest of your day.
Thank you, you too.
Okay. Okay, and then I believe our last matter of the day is CR 2026-173, the O'Donnell matter. This is the date and time set for arraignments. Mr. Collins, can you give me an update on service?
Matter needs to be continued so that we can achieve service, Your Honor.
Madam Clerk, I'm going to move this matter out to May 18th. I'll set that at 3:30 in the afternoon for a continued arraignment. Mr. Collins, is this assigned within your office?
It is assigned to Mr. Van Acker.
Okay, and I'll note it's Mr. Van Auker's matter. Okay, that'll be all then on the O'Donnell matter. Thank you. And I think that is the end of our calendar. So we made up for the morning.